mind, 7 o'clock as opposed to 6 o'clock. Right? But we hope to see as many people there as possible. I'm going to turn it over to Kira to introduce Al Rosenblatt. But again, thanks for coming, everybody. If you have any questions about tomorrow's program, seek me out afterward, and I'll be happy to give you more information. Kira, all yours.
Hi, I haven't had this many people since Paulina Poroskova came to the shop like in a snowstorm, so welcome everybody. I'm so excited to be here tonight and to do this program in conjunction with the library and the Historical Society. I always feel like the more people band together, the more people get the word, and so it's really lovely to see so many friendly faces, almost everybody I feel like who I know or have seen before, and a few new people, which is really great, so thank you for coming. I want to introduce Al. So Al Rosenblatt is a lawyer and a judge, and I said out loud today at the bookshop to somebody, I said, I have to introduce Al tonight, and I thought I was going to get a little bit more of a bio in the book, but like the bio is only this little thing in the back, and she said, the one thing you need to know is that Al Rosenblatt is funny, smart, gracious, generous, and the most delightful dinner companion ever. So, everybody owes it to
And one really does not need or want an introduction, considering that I know so many of you. I was getting prepared to give a talk to two people, and my opening remarks were, well, you two people really, really care, so I'll spend the next hour and a half with you. But look at this audience of friends and people who really care about the topic. Your being here shows that you care about the topic, which came to me a little bit kind of sideways, and I could just, by way of anecdote, tell you how I came to become involved in the subject. I'd been a local official here as district attorney and county judge and so forth, but when I got to the New York Court of Appeals, which was my last official job as a judge, it was around the building that our court, I say our court, it was our court that decided the Lemmon slave case 160 years before I got there, or before any of the current day judges got there. We didn't know much about the Lemmon slave case. Around the building, it was believed that the Lemmon slave case was an instance in which, unlike the United States Supreme Court, which decided Dred Scott...
A little louder. By
okay.
yourself. You can do it. There's no... Sorry.
Okay. Whereas the United States Supreme Court decided Dred Scott against Stanford in 1857, which was probably the ugliest pro-slavery decision in American history. Our court, on the other hand, as we would say, we got it right, notwithstanding Dred Scott. And that's about all we knew about it. And people just sort of heard the name Lemmon and it made them feel good, but they didn't know much about it. So one day I decided to actually read the Lemmon case, which, as I say, was decided by our court in 1860. If any one of you chooses to read it, I tell you, it is not an easy read. The judges in 1960 did not write the way we write today in simple terms. Judge Dillon's here, and he's one of the great writers, and he writes with elegance, with simplicity and comprehension. The language was much more florid in those days, with verses upon verses and paragraphs and clauses within clauses, so that you almost needed a blueprint to figure out what was on the page. But after reading it 3 or 4 times, I came to appreciate what the Lemmon slave case was all about. And when you do that, and you become familiar with the case itself, it's not long before you start becoming familiar with the people involved in the case. So the case is no longer a mere legal abstraction, but then you realize, hey, this deals with real people. And this was a case in which 8 people who were enslaved, owned under valid title by Virginians, landed up in New York by a quirk of travel plans. And when the abolitionists found out that these 8 slaves were on board a vessel in New York Harbor, the abolitionists said, okay, let's see what we can do to free them. So they got them somehow on dry land, and as lawyers will do in these situations, sued out what is known as a writ of habeas corpus. I don't suppose that you know the intricacies of a writ of habeas corpus, but it is a legal device, one of the cherished vehicles of freedom that we've had going back to English common law, in which someone who is imprisoning someone, whether it be a sheriff or a police officer, or someone who does not have custody of a child, or in this case, a slave owner, is brought before the judge, and the judge says to that person, by what right are you holding this person in custody? Now, this happens every day in the United States dozens of times, and it would be the police officer or the sheriff. Well, the reason we're holding this person is because this person just robbed a bank, and the judge would listen to proof and say, okay, fine, or not, as the case may be. But it works, and it did work in cases of enslavement. So the issue before the judge in 1852 was whether, based on this writ of habeas corpus, they should be discharged because New York, unlike Virginia, was a free state. And the question is whether what happens if you bring slaves to the free state of New York, should they be discharged and granted liberty merely by setting foot in New York? That was the legal issue. So I'm going to ask that you might just look at this timeline for a moment and absorb it, because it's very hard to grasp what's going on here without understanding the timeline. And if you look at it for a few moments, I'll kind of walk you through it, and I think it would get you well oriented. We began New York in the 1620s, and in the 1620s we were all Dutch. We spoke Dutch, our laws were Dutch, our customs were Dutch, and Poughkeepsie and the region here grew up a little bit later. Dutch New York began in Manhattan and in Albany. The Hudson Valley got filled in later. But the Dutch recognized slavery. They were not big-time slave owners, but it was a common accepted practice. When the British came in, the British forced out the Dutch in 1664 with gunboats. And they said to Peter Stuyvesant and company, we the British have a claim in New York that's superior to your claim as Dutch with gunboats. And they said to them, do you want to do this the easy way or the hard way? The easy way is just write up that you're relinquishing it to England, and the Dutch chose the easy way. And the British, to their credit, said, okay, this is being done agreeably, keep on your customs, keep your language, but now we're going to codify some laws. And one of the things the English did was to create the institution of slavery by statute. The Dutch didn't have that. The Dutch did it by just custom and usage, but the English did it by statute. So now I'm about to tell you something which really struck me as extraordinary, arithmetically. Let's say we started in the 1620s. Let's pick a date, 1623. That's 400 years ago. So we've been on this soil, more or less, as a political entity for 400 years. In those 400 years, we in New York have had slavery longer than not. Just think of that. We abolished it beginning in 1799. So that's already like 150 years right there. We abolished slavery in 1799 when Governor John Jay, who was the first United States Supreme Court Justice and New York governor, was the governor of New York, and we began the process of abolishing slavery in 1799, from the period of 1799 to 1827. The last slave was freed in New York in 1827. Any thoughts about this timeline so far? Is it starting to make sense? All right.
Al, when you say gradually, just tell us what you mean by that.
Well, it was rather complicated. Certain people were granted liberty earlier, girls before boys. Boys were continued on, and it was by statute. It was written out very carefully, in part because the politicians of the day, although they wanted to abolish slavery, knew that they just couldn't wave a wand and it would be over because the public was not ready for it. And they were savvy enough politically to do it over basically 25 or 30 years. By 1827, there was no slave left. There were no slaves left in New York. So here we are. But before that time, I'm jumping a little bit ahead. In 1787, 10 years before we abolished slavery, we wrote, when I say we, I mean the corporate we. None of us were around in Philadelphia to write the Constitution in 1787, but that's when the Constitution was written. And if you look at the Constitution, which some of you may be carrying it around in your vest pocket, you can open it up and you look at it, and you find a number of things that today is really astonishing. Number one, that there's a clause in the United States Constitution that is still there. It's called the Fugitive Slave Clause, and it says that any fugitive slave who escapes slavery must be returned to the owner. That's right in the United States Constitution. So we have to be a little bit modest when we say the Constitution was a document of abject freedom and liberty. It was for many, but not for all, obviously, because we abided slavery. Secondly, in the United States Constitution, you will find a provision dealing with congressional representation. And we all know from junior high school and so forth that when it comes to congressional representation, the bigger the state, the more populous the state, the more people in the Congress. Unlike the Senate, every state has 2 senators, and that's that. Small state, big states, they both have 2 senators. But when it comes to the House, the House of Representatives is configured based on the population. So right away, a dispute broke out. What about South Carolina, Georgia? Did they count slaves? Well, Georgia and Alabama and Virginia wanted to count slaves because it would enormously fatten up the congressional representation. Why wouldn't they? The Northerners, on the other hand, was saying, why should you count them even as one? Because you don't even regard them as people. So you regard them as chattel. So they reached what is known as a 3/5 compromise. Some of you, we may remember this from high school, and it's in a way, in shorthand, it would say that that for African Americans they count as 3/5 of a person, and that's the way to put it. But technically speaking, it meant that for every 500,000 slaves, 300,000 people were counted in the legislature, the United States Congress. This gave enormous political power to the South, and it also motivated the South to increase the slavery. Wouldn't they do that? Slavery was, the importation of slaves was banned in 1804 as part of a compromise, but the South didn't mind that because if they started with 1 million slaves, all they had to do was reproduce and it would grow into many, many more. And the ways of reproducing the slaves, or as they would call increase, was what we would today would consider ugly and appalling. Namely, when you see slaves with mulatto children, what does that tell you? It means the slave owner goes into the barracks, or his friends, goes into the slave quarters and reproduces so that there's more slaves, because they would follow the line of the mother. And that's how the South increased the number of slaves, the number of mulattoes, and expanded their political power so that up until the Civil War, the federal laws were overwhelmingly pro-slavery. Some of them were shockingly pro-slavery. The Fugitive Slave Law of 1793 was shockingly pro-slavery, and the Fugitive Slave Law of 1850 was even more so, as one of the provisions of the Fugitive Slave Law of 1850. Not only were everybody supposed to return a fugitive, but the judges in the North were obligated to do the same if they found that it was the escaped slave. And also, you may be shocked to know that the federal magistrates who would decide on whether to send back someone as an alleged fugitive got paid double if they sent the person back than if they found that the person was misidentified. I mean, think of the due process violations in which a judge, a federal magistrate, or federal commissioner, as they were called, were told that the federal commissioner would make twice as much money by ruling in favor of the slave owner. That's actually written down, and it wasn't until maybe 30 or 40 years later that the United States Supreme Court decided other cases saying that if there's any money on the table, that upsets the apple cart and that violates due process. So that's just a little bit by way of introduction as to what was going on. Through the United States Constitution, some of those provisions, the 3/5 clause, the fugitive slave clause, right in the Constitution. And then in 1799, John Jay, as governor, led the move to abolish slavery in New York, which was a banner day. Then something else interesting happened. As part of that arrangement where we abolished slavery in New York in 1827, we said, okay, no slavery in New York, but we still want to be friends with Southerners, and a lot of us are related to Southerners, and we know that the Southerners have been coming up to New York, they've been coming up to the theater, they come from South Carolina, they come to visit relatives in New York, and they're used to bringing their slaves with them. So we're going to allow that to continue, but they can't stay in New York except for 9 months. So this was a 9-month provision. The reason I'm stressing this, it sounds a little bit technical, but it's very important in terms of the Lemmon case. So all you have to remember in this context is that by statute of 1827, we allowed Southerners to bring their slaves with them into New York to sojourn, but not longer than 9 months. And that went on for a time. In 1841, 14 years later, the legislature took that 9-month phrase and they just drew a line through it. And as any lawyer knows, when you put a line through a provision that says 9-month exemption, 9 months minus 9 months is 0. And that's the statute that Judge Payne was dealing with when the abolitionists asked Judge Payne to release the slaves based on a statute. Judge Payne, before whom this writ of habeas corpus was brought, did not have to swing for the fences. He did not have to use flowery language about freedom and quote the great philosophers. He did some of that, but he wrote a decision that was technically a gem. It was just so tight. He said, I'm a statute. The 9-month provision is stricken. I'm just the judge. I'm just doing what the legislature said. 9 months minus 9 months is 0, and he discharged the slaves in 1852. Just so you appreciate the year 1852, because some of you will recognize that 1852 is not long before the Civil War. Actually, 8 years before the Civil War. So as the regional hostilities were growing north and south, the Lemmon case was proceeding through the appellate courts in New York, and then ultimately on its way to the United States Supreme Court, which it never got there because the Civil War intervened. I have no doubt whatever that had the United States Supreme Court got their hands on the Lemmon case, they would have reversed it. I think, and I'm not alone in that decision. They gave us Dred Scott, the ugliest racist case that we ever had, and they were just priming, getting themselves ready for Lemmon. That would have been the second shoe. Thank goodness it never reached them. It took bloodshed. As a matter of fact, the Lemmon case was affirmed. My court upheld Judge Payne's decision in April of 1860.
Was it unanimous?
I'm sorry?
Was it unanimous?
No, it was 5-3. Interesting, right? And we could talk about that a little bit later. Thanks, Fred. It was 5-3, and that was April of 1860. 9 months later, South Carolina secedes from the Union, the first state to secede. And in their secession, you can find this online, just go to the South Carolina Declaration of Secession when you go back home or whatever, and you will see that they gave 6 or 7 reasons, and one of them was the Lemmon case. They said, we've had it with New York. In New York, we can't even bring our slaves in. See, that's a reaon to get out of the Union. So we feel pretty good about South Carolina's secession statement. It was provoked by the Lemmon case. So let's, any thoughts about the chronology here before I go through some images? Anybody? Comments? Right? Straightforward. Okay. All right, here we go. We're going this way. All right. This in my research to become acquainted with the Lemmon case, I was able to identify the actual location of the Lemmon farm in Bath County, Virginia, and I got to know some of the folks out there. I retained a lawyer in Bath County, Virginia, a really nice guy, and he was able to identify the actual farm, and he took a picture of what the Lemmon people and the slaves would have seen if they were looking out from their property. It's almost in West Virginia. This is something that struck me as extraordinary. I guess if you think about it, it kind of makes sense. But when you think about the relationships between black and white families, here were the rules of the game. Number one, the thought of marriage was criminal. Not only illegal, it would have been criminal. The thought, however, of fathering a mulatto child was routine. So that's one curiosity. Secondly, when you think about intimacy, the notion of black women nursing white babies was common. And in the literature, and some of that. So when you think about these relationships, A owns B, and owns B like a piece of chattel, and yet, look at the intimacy of these images. Isn't that extraordinary? It struck me as extraordinary. I thought it's worth putting it into the book. By the way, if anybody has a comment, I'd like this to be a little bit, conversational, if that's okay, so please feel free. I hope. The other thing that was extraordinary about the notion of enslavement, when you think about it, it had to be this way if it's going to work. In order for slavery to work, there must be abject subservience and ownership. There cannot be trade unions when dealing with slavery. Nothing is negotiated. It is abject ownership, domination, subservience, so that a funny look could bring on a whipping and an attempt to escape can bring on a killing. And the other feature of it, which we find so shocking, is for slavery to have worked properly, there could be no family units that would be faithful to one another. The owners were not looking for parents to be faithful to children, children to be faithful to families, husband to be faithful to wives, wives to be faithful to husband. Marriage was outlawed among slaves. All the faithfulness had to be to the owner, to the master, which meant that, per se, families had to be broken up. Children had to be sold at auction. And here is one image that is so touching. As you can see, the words, there's at the auction, there's the mother, and the baby's being sold off, and the mother saying to the auctioneer, "Buy me too, so I can stay with the child." This scene was probably repeated countless times, but I just happened to find that particular image. I find it very touching and moving, and I don't think you can really appreciate how ugly slavery is. I mean, although we do, but when you see something like this, it makes it even more horrifying. So the Lemmon family, for reasons that are not entirely clear, but I'm going to infer that the Lemmon family, there were 9 of them. The 2 Lemmons, Juliet Lemmon and Jonathan Lemmon, and 7 children Lemmons, white, and the 8 slaves. So there was 17 in all on that property. They decided, the Lemmons decided that life in Bath County, Virginia was difficult to operate the farm, and you can infer why. It needs heavy labor, and of the 8 slaves, 2 were moms, pregnant much of the time. The others are tots, and 2 boys who were not big strapping guys, they were too young. So you can't run a farm without that kind of labor, and Texas was beckoning. Texas is saying, hey, slavery, come on to Texas, you got a lot of land, you can practice slavery. So they picked up, and they said, let's go to Texas. Today, if you're in West Virginia, or the extreme west side of Virginia, and you want to go on a vessel in the Atlantic, you drive to Richmond, maybe 2 hours would take on the superhighway. Back then, it took 16 days for them to get from Bath County, Virginia to Richmond. And this was the road. There's pictures of it, and this is actually what it looked like. And they called it the 3-notched road, and people around there still know the name 3-notched road. And the reason they call it the 3-notched road is because you get lost, but you could look for trees that would have 3 notches on them and say, oh, okay, we go through this way. So here they are, imagine probably 3 or 4 wagons, 17 of them, going through mud like this, breaking down, getting to the next town where there might be a wheelwright or somebody to fix the wagon or Lord knows what to get to Richmond, and it took them 16 days. They get to Richmond, and here's what happens. Well, I'm going a little bit ahead of myself. In the South, the fable and the way they justify slavery was by saying, oh, the slaves have it great here. In the North, the black people live in the freezing cold and no one cares about them. In the South, this is where the slaves live a great life, and that's where images like this come up. I just put that in as a little sideline. And make no mistake about it, if we get too high and mighty about our own legacy, New York has an ugly history of slavery up until 1799 and even a tiny bit later. That sort of ad, if any of you have subscriptions to something called newspaper archives or historic newspapers, you go in there and you punch in the right words like reward or black or slave, and you'll see countless ads of this kind for escapees. Now, this is interesting because in the North we began to develop anti-slavery societies, and I felt pretty good about when we saw from the Dutchess County History Society that the anti-slavery group met in Pleasant Valley in the home of someone named Stephen Flagler. I guess that name,
Yes.
does that name ring a bell? Yeah, right? Betsy, do you know? So the Flagler family, right? I tried to trace them, but they left here some time ago. But this was, I think, we're not sure, but I think that house is the one right after what used to be the covered bridge in Pleasant Valley. That house still stands. So we visited the owners of that house 2 or 3 years ago, and I said, are you aware that you might be on historic ground? And he says, yeah, we think this might be right. He says, come on downstairs. And he goes downstairs in the basement, and he shows me a room with and he pulls a big pillar aside, and there's like an empty cavern, which suggests that that's where they may have hid escaped slaves. Because we were part of the Underground Railroad, which, as you know, was not a railroad at all, but just a series of houses, mostly Quaker, that would help one family along the way, or many families along the way, such that the Underground Railroad was the vehicle by which, I'm going to say, more than tens of thousands, hundreds of thousands of escaped slaves went up through the Underground Railroad across central New York, sometimes up through the Great Lakes. One of the terminus points of the Underground Railroad was in Buxton, Canada. which I don't know much about Buxton, Canada, but I learned that that's where the terminus was, or one of the main terminus points. And I contacted the historians in Buxton, Canada, and found one chap named Brian Prince, who's a really great guy, himself a descendant from escaped slaves, and he has records, such as they are, massive amounts of records of escaped slaves who wound up finding freedom in Canada. Canada had no extradition treaty with the United States, so they were safe in Canada. They were not safe in the United States because slave catchers would grab free slaves. Slave catchers would grab free blacks and claim that they're escaped, bring them before a federal commissioner who would cheerfully send them back south. That was what was going on in this in this country at that time. That's another depiction about how great life was for the slaves. This is the propaganda in which they infused themselves. You know, the notion of the happy slave, you know, with the banjo, that's almost become a caricature, but it began because the North began to appreciate, which we did not in 1730, 1740, 1750, the immorality of slavery. When the immorality of slavery started dawning on us at the beginning of the 1800s, the South started to justify slavery by saying, well, sure, slavery's in the Bible, anybody knows that. You know, the biblical figures had slaves. This is the curse of Ham. That's why it makes it okay. Also, the slaves in the South are very, very happy, unlike in the North where black people are mistreated. And they would put out images like that of the so-called happy black slave. When the case was litigated in New York, Elijah Payne was a lower court judge, equivalent maybe to the civil court of the city of New York. And when I'm getting back now to the story of the slaves, excuse the tangent, when the Lemmon family left Virginia on the way to Texas, they got to Richmond after, I said, after over 2 weeks. They get to Richmond, and the people in Richmond gave them bad news. Oh, you from Richmond? Yes, you want to get to Texas. Well, you go by steamer to New Orleans and from there to Texas. But the last steamer just left, and the next steamer is not for another 2 weeks. But if you want to get to Texas or to New Orleans and then Texas, here's how you might do it. Go from Richmond to Norfolk. From Norfolk, you go to New York, and out of New York, there's a steamer almost every day. And they said, well, okay, you're smiling, Tommy, get to New York. And they said, well, is that such a great idea to get to New York? And they said, no, it's okay, you'll be okay in New York, you know, things are going to be fine in New York. Little did they know. So they get to Norfolk, which is not easy. And then from Norfolk, they get on a steamer to New York with the intention that they're going to go from New York to Texas by way of New Orleans. Well, they're on the steamer in Norfolk, leaving Norfolk, and a guy by the name of Nathan Lobham, who by the oddest coincidence happens to be a free black from Poughkeepsie. I mean, when I saw it, I said, I can't believe this. Of all the cities, you know, of all the gin joints in all the world, she's got, of all the cities, he comes from Poughkeepsie. So Nathan Lobham sees the 8 slaves in steerage, and he approaches them and says, in effect, hey, do you guys want to be free? Now imagine a question like that to people who couldn't even process the notion of freedom. In their minds, for their entire lives, they were chattel to be owned. And the notion of freedom must have been so exotic and so frightening and so inexplicable that the 2 teenage boys said, no, we don't know about that. Like, you know, where are we going to eat? How are we going to be free. What does that mean? We're going to be cast to the wolves. We can't be free. Where are we going to get food? The two moms, however, Emmeline and Nancy, Emmeline being the oldest one, the senior, 23 years old, with 3 children, twins 5 years old, and another little tot. Emmeline is the oldest, and she was the dean, and she said, yes, we're gonna, let's do it. And Nathan Lemmon said, okay, you just got to do what I tell you to do. So this turns out to be, to me, unexpectedly, almost like an adventure story in the midst of this legal abstraction. So Nathan Lemmon, yeah.
There were no men, male slaves, other than the boys?
The 2 boys, one was like 13 and 15, and the rest tots, 2 twin boys, 5 years old, and the rest little girls, tots, and the 2 moms, Emma, 23, Nancy, about 17. Yeah, thanks. And that's the group. So Nathan Lemmon, when they embark in New York Harbor, does something very cool. He sends out 3 messages with one of his helpers. One message went to a black restaurant where African American people would hang out near the docks, just saying there's 8 slaves on board, just to tell the folks about it for whatever value that might have. It was almost a shot in the dark. But the other 2 letters were very pointedly directed. One of them was directed to a guy named Louis Napoleon, with whom I became very familiar through this book. Louis Napoleon was one of the great conductors of the Underground Railroad. He would hang around on the docks day after day after day, and he was one of the people who would see to it that a fugitive would be identified and he'd get the fugitive on the way in the Underground Railroad. Louis Napoleon is not well known, and he was not a literate. He signed the writ of habeas corpus with an X, and we treasure that X. But he found his way into the precincts of Ivy League education because his papers are at Butler Library at Columbia. All of the Louis Napoleon's records that he maintained with one of the editors of the Anti-Slavery Journal are at Columbia University, Butler Library. They're available online. They are astonishing. Tens of thousands of people they sent up on the Underground Railroad. So that was the second letter that went out to Louis Napoleon saying, hey, there were 8 slaves on board. The third letter, and Lord knows how Nathan Lemmon knew what lawyer to give this to, but he gives it to a lawyer, he gives this to a lawyer named Culver. Was that? Oh yeah, a lawyer named Culver, Erastus Culver. Again, very obscure, you can't even find him online, but with a lot of research, you know, with the computer and so forth, you can eventually find people, and I eventually found a great-grandson of Erastus Culver who was aware of him, not to the extent that I was able to research, but I became friends with the guy. His name is Henry Ryder, and I said, there is no picture of Erastus Culver, and I would like a picture of Erastus Culver for the book because he is one of the heroes. He went to court, and he was fearless in, you know, in the arguments that he was making. Is there any way we can see what he looked like? And he says, I have a picture of Erastus Culver on my mantle. So we were able to get that, and you'll find it in the book. He was a handsome young dude. And so I got to know Henry Ryder a little bit, and Erastus Culver. I got to know Erastus Culver through his other writings, and a lot of what we know about the actual events in what we might call an adventure came from Erastus Culver, who after the Civil War spoke to an abolitionist group, and he told the story of his role in the Lemmon slave case. Can you imagine finding something like that 150 years later? It was like a gem. When I found out, was able to get his talk that he gave to this anti-slavery society shortly after the Civil War with all of his remarks, it was like, oh my, and it was, what a rip-roaring talk it was, and I'll tell you a little bit about it. These two gentlemen came into the case later on. As the case progressed, the lawyers became more important, and by the time the case reached New York's High Court, after Elijah Payne at that level did rule to discharge the slaves. I'm not telling you any big secrets. Paine ruled with the slaves, and they got them on the Underground Railroad immediately. But the case proceeded in the New York courts to what is today the Appellate Division, then called General Term, and then to New York's High Court. So by the time they were in the High Courts, then two of the most eminent lawyers in the United States were now representing both sides. Now it was no longer the Lemmon family, they were long gone, and it was no longer the slaves, they were long gone. This was now a battle between Virginia and New York. And Virginia hired Charles O'Connor, the most prominent lawyer in New York at the time, and maybe in the United States. And when you read some of his arguments, you would be shocked. He must have misjudged his audience, but I'll get into that a little bit later. On the other side, what we would call the good side, is William Evarts, whom I come to greatly admire. And it just shows you, a guy like William Evarts, he was a great man, a great lawyer. He was on the right side of the issue, and he was eloquent. And he made the arguments in New York's highest courts on behalf of freedom for the slaves. And you look at William Evarts, and you look at his own line. His grandson is Archibald Cox of the Watergate prosecutor. Down the line, Harvard Law School professor Archibald Cox, and there's his grandfather. And the Evarts family is like that. That's how distinguished they are. So I was feeling pretty good about that. Any thoughts so far?
Well, my sister Molly was, I don't know if you call it an au pair, but she worked with a family named the Everts. And they had a summer house in Maine, and when she was a kid growing up, she spent some. And the father's name I know is Bill Everts. There's got to be a relation. Don't ask her.
Yeah, it seems there's a good chance of that. It's not the most common name, yeah. But he's quite a guy. He then, by the way, these two same people, this is also an astonishing coincidence. After the war was over, and Jefferson Davis, who was, you may remember, was president of the Southern Confederacy after they broke away, Jefferson Davis was being tried for treason, represented by Charles O'Connor, the United States attorney prosecuting Jefferson Davis for treason is William Evarts. And what does Evarts do? He says, you know what? It's a little bit like Gerald Ford. He just said, you know what? It's going to rip this country apart. They declined prosecution, which U.S. attorneys can do. And I just want to pat Evarts on the back because I think, in retrospect, that you can disagree with that judgment. But he just felt that as a political matter, Jefferson Davis is gone, the Civil War is over, this Reconstruction is starting. Why do we want to open up that and start a treason trial against Jefferson Davis? His judgment was, no, just pass it. Again, I say some of you may agree or disagree with that, but that was his judgment, and I think it's to be respected.
Now, where did the slaves go after they were freed? In other words, after Paine's decision, where do they go?
Did everyone hear the question?
Sorry?
Yes, I just want to make sure everyone heard the question.
Yeah. What happened to the slaves after they were freed? So I contacted my friend Brian Prince in Buxton. He's a very nice guy, and he has the Buxton Museum, and he has more records than anybody on the fugitive slaves. And I said, Brian, you know the Lemmon case? He said, yeah, of course I know the Lemmon. He said, you know what became of the 8 slaves? He says, oh no, you know, a name like Johnson, Tompkins, we can't. The dates are all over the place. We can't. No. He said it'd be nice if we can find them, but no luck. So the last, as a matter of public record, the last we heard of them was when they left New York for the Underground Railroad. I was about to send the book to the publisher, SUNY, and I've been corresponding with Brian Prince in Buxton. I called him. I said, Brian, can you give me a sliver of a sliver of a sliver of a sliver of a clue that maybe we could find one of them? And he says, let me get back to you. A day or two he gets back, he says, I have reason to think that one of the 5-year-old twins named Lewis Wright was in Lansing, Michigan after the Civil War. I said, well, okay, now, now you're giving me something. So Julie will tell you that our living room looked like a police scene with lights and flashes and arrows and tape going all over the place. And then it was probably 1 o'clock in the morning. I said, Julie, I think I got him. I think I've got Lewis Wright. The dates match. He's born in Virginia. The birth date is close enough. He moved, I had him getting married in Ypsilanti, Michigan, right after the Civil War. I said, I think this is the guy. And once having identified Lewis Wright in Lansing, Michigan, after the Civil War, at that point, I didn't know this, but Lansing, Michigan is heavily populated with African American population. I didn't know that. But there's a substantial African American population, which means that unlike the New York Times of that day, when black people got married, it was in the newspaper in Lansing, because that was their community. Unlike in the New York Times, it was only like the fanciest people in New York, not like the likes of me, but the fanciest people in New York would be on the society page in the wedding. But in Lansing, marriages were reported. So with marriages, death records, Michigan marriages, census records in Michigan, I was able to get 7 generations forward to a guy named Victor, I think his second name is Wise, I forget his second name, but a guy named Victor X, and I found his phone through, the computer and so forth, and I had a phone call that went something like this. Just imagine now, I'm on the phone. Hello, my name is Al Rosenblatt. We've never met. Who's this? We've never met, but I have reason to think that you and your family may occupy a very important part of America. Who's calling me? What are you calling me? So after 3 or 4 assurances that I was legitimate and had no insurance policy in my pocket, and I think the crusher was when I went through the line, I said, it was something like, is your great-grandmother Flossie Moore? The silence. Yeah. I said, well, actually, this is a legitimate call. And then after 10 or 15 minutes, he loosened up and we sort of became friends, and to this day. So he then learned for the first time that he knew about Lewis Wright. He knew that he was descended from Lewis Wright, but they did not know that Lewis Wright was one of the 8 and was involved in the Lemmon case. They had their own version of where Lewis Wright came from, which I kind of had to disabuse him a little bit as to what the real story was. But he was very happy to know that we were able to locate the lineage, and we had a Zoom with that chap's family in Lansing. I'll probably be going out there in maybe sometime in the summer, get to see them. It'll be a real joy to get to see them, because the tears were flowing when, I explained to them how important this case was in American history. Well, tears are flowing both ways, because imagine here, I'm working on this book like for 4 years, and I suddenly found one of the descendants, the 5-year-old. The other 7, no trace of them. Even the twin. They knew that he had a twin, but they had no idea what became of the other twin. But they knew that Lewis was their great, whatever. So I'm going to get over to that in a little bit. I'm a little bit out of order here, but I think you have enough context that you can fill things in. In February 1860, the Lemmon case was before New York's High Court. Lincoln was aware of this, and Lincoln, in his notes, and people around Lincoln were saying, beware, if this case reaches the United States Supreme Court, this is going to be the second shoe to drop after Dred Scott, and Lincoln did not like it. Okay, there they are. Now, okay, Lewis, our guy is Lewis. It wasn't easy finding him, because when I didn't know how to spell the first name, Louis or Lew, so that even complicated it more. And the name Wright is far too common to do easy background research on, but there they are. The family, after I had reached the family, they sent me this picture. Imagine that. So there they are. They didn't want to, as I say, our guy's here. This was the 5-year-old. Emmeline's 5-year-old. This is the other 5-year-old of whom we don't know anything, nor does the family. And the other 6, we don't know what became of them. We don't know what became of Emmeline, who, to my mind, Emmeline may have been one of the true heroes, not only of this story, but of American slavery. Because, as you might read in the book, if any of you get it, when they were in the courtroom before Judge Elijah Payne, nobody knew how Judge Payne was going to rule. Good lawyers making good arguments. The lawyers for the Lemmon owners were saying, Judge Payne, you can't do this. They have title in Virginia. You're a New York judge. You can't strip a Virginian of title to what they own. And the New York lawyers were saying, well, we have a statute in New York saying when they set foot in New York, you apply New York law. And Judge Payne had to do what lawyers know to decide a point of conflicts of law as to which law to apply, New York law or Virginia law. So they're all sitting there in the courtroom. No one knows how Judge Payne is going to rule. I dare say Judge Payne, being to my mind a truly great guy, himself didn't know how he was going to rule. He's listening to arguments. But fortunately, we have the transcript, the actual record of the arguments that the lawyers were making before Judge Payne. And the lawyers made very good arguments. The lawyers from Virginia got Judge Payne very, very uncomfortable when they said, you have no right to do this. No one has ever stripped a Virginian of legally owned property. You don't have jurisdiction to do this. And they made him squirm. The New York lawyers, on the other hand, had other arguments that were, of course, on the other side. So no one knew how he was going to rule. But this is a fascinating little event that took place at the trial in the courtroom, as reported in the newspapers in the North and in the South. So it's bona fide because the newspapers in the North and South have practically the same conversation. Juliet Lemmon, the owner, goes from her side of the courtroom. She walks over to Nancy and Emmeline, who are nursing babies. And the owner, Juliet Lemmon, says to them, why are you doing this? Why are you breaking up our family? You, slaves, are our only assets. You're all we have. Aren't we one big happy family? Don't we, quote unquote, this is an actual quote, don't we eat off the same plates? Aren't we like one big happy family? Nancy and Emmeline start crying when they hear this. Imagine being told by your owner, and you've never known anything else but ownership, when your owner is saying, don't do this. And imagine what's going through Emmeline's head. And in the book I write, now I don't know what the thinking process was in Emmeline's head, but I said in the book, she may have seen something in Judge Elijah Payne's eyes that she thought she's got a chance with the judge. It turns out she was right. I don't know whether she saw anything in his eyes, and I don't know whether his eyes held anything at that point, because at that point, of course, as you know, judges, he was probably open-minded. He was probably saying, let me hear argument, this is new. So we don't know what he was thinking, but he eventually did rule in her favor, and Emmeline and Nancy told Juliet, no, we're going to take our chances with the judge, and they said that in tears. Imagine the backbone of Emmeline to say no. The Southern papers had a slightly different version. No, I'm sorry, the Northern papers had a slightly different version. They both had the same conversation, but the Northern papers said, no, we're not part of one big family. You sold my husband. The Southern papers didn't have that one phrase. In all other respects, the conversation was identical. So what actually happened, we'll never know. It might have been something halfway between, but we do know the conversation took place. We do know that Juliet Lemmon urged the women to go back, and the women just said no. Isn't that extraordinary? I'm sorry. Anybody? Yeah.
Quickie question. What did I haven't studied this since my high school days, of course, but what did they act, I don't want to call them slave owners, but the southern plantation owners, what did they have that act, like today you have a deed for your property, you have a title for your car. What did they have that actually said that the slaves belonged to them?
Two things: the law that provided for ownership, and secondly, wills and estates. When people died, they left in their will, I leave the wagon here, and I leave my slave Ben, and I leave my slave Sarah to my child, I leave my slave Toby to so-and-so, I leave my slave so-and-so to my other children, and they would distribute them around. Our 8 people were descendants of a guy named Douglas, and we have the will. I have his will, in which he bequeathed the slaves to Juliet Lemmon. So she owned them. But under Virginia law, when she was married, the husband took ownership, back before the Women's Property Act. You're not shocked to hear that either. Women not owning property, but Jonathan Lemmon owned the slaves. So that was the answer. Basically by sale a car, a wagon, a horse, a slave, by sale, recognized, chattel, auction, buying a slave at auction, pay the auctioneer, take the slave, you own the slave under Southern law, and by bequest and will.
Okay, but did he get like a receipt or something? Did he have anything written in paper or?
Will.
He did.
The will. Juliet had the will in which she inherited the slaves.
Yeah, but I thought when they were first, I think if I remembered it correctly, that they went to the docks in New Orleans and the auctioneer said, "What am I offered for this person?" Right? Something like that. So when I bought the slave, when I bought the slave, did I get a receipt or something? Or?
I imagine.
I gave the auctioneer some money, but
the auction, I imagine the auction would give title. A regular transaction, like selling anything.
Yeah.
Yeah, sure. There probably was a receipt. Yeah, I would imagine.
I'm just curious.
Sure. Makes sense.
Yeah.
Makes sense. Yeah.
So we did an hour, that was amazing.
Oh, okay. So.
Do we want to ask if there are any final questions that anybody has?
I have a question now. Most countries have constitutions, but it's very difficult to find a country where there is such reverence for the Constitution as there is in this country. And parts of the country reverence for the Second Amendment, and we know the genesis of that, which was to exculpate the militias when they would murder blacks that were running away. Now, what really, in fact, we even think of it as written by God in many parts of the country. What explains this when we know the deficiencies and the defects, the anti-humanity, indeed, as you've talked about in parts of the Constitution? What explains American reverence for this very flawed document?
Well, I'm the one who used the word, and I join with you that it's flawed. It's also perhaps the noblest document ever written in terms of its freedom, its provisions for freedom, due process, and equal protection. It was not 100% that way because a sizable number of people in the population did not enjoy those freedoms. But as an abstraction, when Jefferson and others spoke of equal protection for most of the country, but not for the blacks, and for the notion that we no longer are subject to George III, the English monarchy, we created in 1787 the first document by which the people governed themselves. This was unheard of in the world. We emerged from George III in England as a monarchy, came to the United States, functioned as a group of states for a time, and then say we want to stitch ourselves together as a nation under a banner of freedom and self-governance. And that's why the words of the Constitution begin, Robert Morrison, the stylist, "We the people of the United States." These were high-flown ideas, noble, and I believe in them, I concur in them. I just admit that it was imperfect, because it was imperfect for a whole bunch of people. Huh?
The flaw was pretty big. I mean, it wasn't
a lot of people.
It was the Bill of Rights that came along.
The Bill of Rights, that's right. As Betsy points out, that a lot of the states didn't want to go along with the 1787 version because it lacked a Bill of Rights. And right here in this county, at the courthouse, Melanchthon Smith said, "We don't want to sign on to this Constitution because it doesn't have a Bill of Rights." And Melanchthon Smith in Dutchess County, who lives not far from here, contacted James Madison and said, "We're not ready to sign this because it doesn't have a Bill of Rights." And Madison wrote back and said, "We will give you a Bill of Rights at the first Congress in 1791, and he did. Madison was going to do his word. So the Bill of Rights is another great expression of freedom. First Amendment, free speech, freedom of religion, disestablishment. Fourth Amendment, freedom from search and seizure. Every day in the courts, Judge Allen has had, Judge Allen had loads of cases, Judge Dillon. Every day of the week they have a case on the Fourth Amendment. Did the cops grab somebody properly? Every day. Fifth Amendment, police questioned someone in Judge Dillon's court. Every day. Was the questioning properly preceded by Miranda? These are all arising out of the Bill of Rights. Sixth Amendment, right to counsel. Sixth Amendment, right to an open trial, and so forth. Eighth Amendment, forecloses cruel and inhuman treatment. So these are all came with the Bill of Rights. And if I did speak freely and about the flaws, I'm one of those who revere our Constitution. I do. I admit that it's flawed and that has serious flaws as we described, but I don't think that should just throw it into the wind. Okay?
Thank you.
Good. Thank you. Here he is.
Al, did the Court of Appeals in the Lemmon decision say anything about Dred Scott?
Did everyone hear the question?
Oh, wow. Okay, this has to come from a lawyer. And a judge. Okay, you ready? This is, all right, now, it's going to get a tiny bit technical, but this is not going to go, I don't think it should go over your heads. So here's what it is. Dred Scott was articulated by the United States Supreme Court, in which they said a great many things, among them that no black person could ever become a citizen. And that's shocking, and if you read the Dred Scott decision today, you'd be appalled at how racist it could be. So the Dred Scott decision goes something like this. Dred Scott brought a lawsuit for his freedom in the state of Missouri in a federal court. In order to bring a suit in a federal court, it requires citizens of different states. Just believe me on that for the moment. It's called diversity of citizenship. So a federal court is a forum where people from different states can find a forum that's not the state of one of them. And it's supposedly for neutrality. We don't really believe that anymore too much, but that was the reason for it. So in order to bring a suit in a federal court, you have to be a citizen of a different state than your opponent. The United States Supreme Court began by saying, Dred Scott cannot be a citizen of anything because he's not human and can never be a citizen. Therefore, he lacked capacity to bring a lawsuit. That's Dred Scott. In the opening paragraphs. Then Dred Scott goes on, and Roger Tarney then writes 40 pages of ugliness. When it reaches our court, Judge William Wright said, "Oh yeah, Dred Scott, yes. Oh yeah, Dred Scott says that nobody can ever deprive an owner of a slave, and we know Dred Scott, but we don't think Dred Scott applies because that case was decided strictly on jurisdictional grounds. He couldn't bring a lawsuit, and the rest is all dictum, so we choose not to follow it." Pretty cool, right, Bruce?
You're right, though. The Supreme Court, if it hadn't been for the Civil War, the Supreme Court would have reversed.
Take it from Judge Sheikman. The Supreme Court would have reversed the Lemmon case, yeah. Yeah.
So why wasn't this case removed to the federal courts before it got to the Court of Appeals?
They didn't have removal provisions in those days. It was straight up the line, and I don't think anybody felt it was necessary anyway. We know what the Federals would have done. They would have ruled with the slaves for sure. But they thought, the Southerners thought, well, this will get to the United States Supreme Court. Some historians, it's just a bit of a sideline, but it's fascinating in my own little travels. Some historians said that the case reached the United States Supreme Court, but it was never decided. So I contacted, at the Library of Congress, a really nice guy named Ennis, and was able actually, after a lot of effort, actually speak to him on the phone, and said, did Virginia ever file a notice of appeal from New York's High Court to the United States Supreme Court? And he gets back to me, he says, I looked. He says, no. I said, I'm going to write it down in a book, and I'm going to quote you. He says, go ahead. Virginia never filed a notice of appeal. I said, did anybody ever file a notice of appeal to the U.S. Supreme Court? He says, no. I said, okay, I'm quoting you, and it's right in the book. It's in a footnote, Mr. Evans, in such and such an email, and it's told me it was never. Now, why not? Virginia had every reason to appeal it to the U.S. Supreme Court because they had a sure winner. Why did they not appeal it? And all you can do is guess. Governor Letcher at the time was very much distracted. There were people that argued that he was soft on slavery. That may have been one of the reasons. Maybe he was preoccupied with the war that was about to come. But I'm going to tell you what I think really happened. I think somebody in Governor Letcher's office in Virginia said, oh, didn't you file it? I thought you were going to file it. Oh, wait, you told me you were going to. That's the real world. That's what happens in the real world. So, who knows? You never know.
I think we had one.
In reference to the Underground Railroad, about 6 miles beyond Milford is the Elliott Clark estate. And that was rumored to be an Underground Railroad stop. And I'm pretty sure, I was 48 years at the Poughkeepsie Journal. I think they did a story on that. I'll see if I can dig it up for you.
That'd be tough. Can you tell us anything about Van Wagenen? He was an expert.
I gave you that article.
Yeah. Do we know anything about the Underground Railroad?
I don't, but I have a question for you if you have time.
Sure.
So we've talked about the fact that slavery existed in New York for longer than it hasn't existed in New York. What do you see? I mean, it was a horrible institution which damaged numerous people's lives, and many, many people suffered. What is the legacy today in New York as a result of slavery in New York, and how it impacts us today, in your opinion? I mean, you've been involved in the criminal justice system. You've seen the disparities in the criminal justice system. What's the result today, and how should we respond to it today? I mean, we can't do anything about what happened in the early 1800s, but what is our response today?
I think it's the duty of every American to take seriously instances of racial inequality. It's our job. We have to do it. We have to be very keen and sensitive to it. We have to go out of our way. We have a lot of, the country is very much divided on this. 20 or 30 years ago, when Derek Bach, president of Harvard, and Bowen, the president of Princeton, two great educators, said the way to compensate is by affirmative action, and these two great educational leaders thought so. Now affirmative action is under attack. There are two voices coming out in the United States. So I know obviously how we feel, but we know that in different parts of the country there's rioting taking place by one group and the other group. So it's something we got to keep our eyes open about, be mindful of it, particularly in the courts. But Bruce, what do you think? You've been on, and Judge Dillon, I left the court a while ago, and you're still on the court. Bruce, you left the court. he's
Can I-
retired, but Judge Dilla's on the court. So let me ask the judges, I'm sorry to put you on the spot, but what do you think about the issue like that, Mark? You want to say anything? Mark's a very high judge in New York. He sits on the appellate division, and he's one of the stars there, and he's a great guy and a writer and a scholar and an author of a book about John Jay.
Yes, we heard this.
Oh, okay.
Al, I came here to learn.
All right, here's what I would say. I actually am going to answer this a tiny bit, which is that now there are a number of people, and one amazing person is a gentleman named Dr. Ibram X. Kendi, and his statement, which is, I think, amazing, is that it is not enough just to not be racist. We have to be anti-racist. So if anybody is really thinking about legacy, and of course, right, you just said we can't do anything about the past, but you can do something about your everyday. And being anti-racist is very different than being quiet or passive or just not being. I have many books at the store. I do workbooks and memoirs and lots of things to help people flesh out their understanding of what's going on. And these two lovely ladies in the front were very clear just now by holding up the book and saying, like, these books would be banned right now in many school systems. Okay? Like, this book would not be allowed to be read. And so that happens every day. Right? So I want to say thank you both to the Historical Society and to the library. We have books here, utmost thanks to Al. We have books if you would like, and I think you'll be signing for a little while. And I'm sure we can kind of continue this conversation. And I hadn't really thought about that bookstore part of this yet, but I think that's an important place to know that all the things that you talk about and all the law has trickled down in many ways, and there are a lot of other people writing really exciting things about it. And this is
There are lawyers in the room, judges, and Betsy Sheik, when there were lawyers, you might ask them about the justice system, but it goes well beyond the justice system, as we know.
There's something I could say about another book. Do you mind if I do?
I'm out of the picture.
I think this book should be read by all of us because I haven't read it yet. I just got it, but it's a real example of what happens and what the results are of slavery.
I've read it and it's readable. It's so well researched.
I'm sure it is, and it's probably good, well copy edited as well. You ask, what do we do? There's another book that's recently come out. You have it. It's called The Bill of Obligations. You're looking for what to do. Richard Haas, who lives locally, has written a book. I've never actually met him, but he's been around for several years in Dutchess County. He is the president of the Council on Foreign Relations. And Richard Haas's book about the Bill of Obligations is a concomitant of the Bill of Rights. He said we should have a Bill of Obligations to go with the Bill of Rights. And we have obligations. And as Kira says, not to sit around and say, I'm not racist. It's to do certain numbers of things. It's a short book. It's easy to read. I'm in the middle of it now, although I know what it talks about, what people should do. First of all, we must all be informed. We must be informed. And we must be active. And he has convinced at least the headmaster of the Hotchkiss School to bring back civics courses. And they're trying to get civics courses back. One of the things that he says, an activity that you could foster is to bring back civics courses to all the schools. We've stopped doing that, and people don't even know how the government is run. We need, in other words, to get active. There are many things in the Bill of Obligations that make it very well worthwhile. And I suggest, after these are all gone, you go to Kira and you buy this book and you buy Richard Haas's Bill of Obligations.
I have about 34 copies of.
I know you do.
So you know. All right, so Robert.
Thank you very much.
Thank you, Al.
Thank you so much. I don't need to.